weapons that are at issue here be returned to him. I'm not satisfied that the burden has been carried in this case. The underlying offense was originally it was a fourth degree that was downgraded to a disorderly person. It was heard in the municipal court, and after a fairly lengthy trial, the court concluded that, in fact, that the defendant had wrongfully entered the premises of the victim. But the facts, based upon the testimony and the transcript that I reviewed, show that there was no use of any weapons, and there really was no threat of use of any weapons. He did enter her home. He had his police uniform on, and he had his weapon with him. But other than a reference to having his hand on his weapon, there was nothing further with regard to that. And since that point in time, there's nothing in the record that I have been provided that in any way shows that there's anything close to the use or the possible use of any weapons, whether he had any kind of weapons, whether they were guns or otherwise. The defendant provides to the court really two reports. One from a Dr. Klugman, who was a licensed psychologist who had performed a psychological evaluation of the defendant and reported on March 26, 1999 to the chief of police at that time in West Hampton Township. And he concluded at the time, and I'll read that. It said, "All legal matters must be concluded before a determination is made concerning the return of Sergeant Baranowski's duty and personal weapons. If Sergeant Baranowski is cleared of any violent behavior, he is psychologically cleared to have his duty weapon returned so that he can continue with his employment." The court, in interpreting what has happened since March of 1999, is satisfied that there was no violent behavior that I believe that the doctor had in mind. There's no question entering someone's home. He was found guilty of a disorderly persons offense under our statutes, and the conduct for which he was found guilty of that is serious conduct. But it was not violent in the sense there was no scuffling. There wasn't any arguments. The testimony is pretty clear that a few words were exchanged, and he left the house. So it was wrong that he did it, and he obviously violated the law. But I don't think that was the violent behavior, as used the terms of Dr. Klugman, that he would be looking for. Secondary to that, there is the report of the treating therapist for a Claire Michaels. She's treated Mr. Baranowski, and also in the record was her notes, and her notes in and of themselves could present some questions. And her last entry was on June 15th, 1999. But on August 10th, 1999, she forwarded to a Stuart Altman, who's been represented to be a formal counsel for the defendant, a note that states as following: "I first saw the above client in July 29th, 1998, and for ongoing sessions since then. He has been working hard in therapy and doing well. I see no reason why Officer Baranowski cannot return to work immediately. He is neither a danger to himself or others. I have worked with the court system for some time, both in my present business, and have also written letters representing both DIFAS clients and court-mandated persons, and my CV is attached." And that's signed by Claire Michaels. Since this report, there really has been no other behavior that's been reported other than what's in the certification of the victim. And there is a civil restraining order, and she certainly would have been free to contact her counsel or come to the court and try to enforce that order. Or likewise, she's not precluded at any time, in the event that she feels that there's a danger to her life, health, or well-being, to seek and obtain another temporary restraining order under the Domestic Violence Act. She's not at all, that's not at all prejudicial. The fact that she had the civil order is not prejudicial to her obtaining the Domestic Violence Act. So under the circumstances and the facts and the findings I've outlined, I cannot see that by a preponderance of the evidence that there is in the words of the statute, there is such as denying the return of these guns would be is necessitated in the interest of public health, safety, and welfare. Therefore, the motion is denied.
Thank you, Your Honor.